Hi, and welcome to our International Surrogacy and Immigration talk. I'm Fiona Lyne, and I'm a partner at Anthony Gold LLP, and I'm joined today by Sarah Pinder, who is a barrister at Goldsmith Chambers and head of public law and immigration. Next slide, please. So on the first slide there, you're going to see a few of the surrogacy terms that you will frequently see if you read anything to do with surrogacy. So the first one is the intended parents. They are often referred to as IPs. The surrogate is obviously the person carrying the baby, and they are the gestational parent or host, but crucially not to be referred to as mother. That is not what is intended by any of the parties to a surrogacy. The two types of surrogacy are therefore gestational or host surrogacy, where there is no genetic link between the surrogate and the embryo, which is provided by the IPs by donor eggs and or sperm, and you will go to a fertility clinic to facilitate that. The other type of surrogacy is where the surrogate uses her own egg and the sperm of the biological father. That's actually a bit more rare. Most IPs want to use their own gametes to form the embryo. So with that, there is no fertility clinic, and that is done by artificial insemination, usually at the surrogate's home. So also a point to note, commercial surrogacy is where the surrogate is permitted to be paid for gestational services, and we'll see that that varies widely across the world. So, and also just an interesting statistic there, which says that parental orders have risen from around 50 in 2005 to 117 in 2011 and to 413 in 2020. So we can see that they are on the rise. Next slide, please. So in terms of the development of surrogacy law, this really started happening in the 1980s, where there was advances in fertility treatment. And the first gestational surrogacy occurred in 1985. Unfortunately, there was a bad press around surrogacy because of a case known as Baby M, and that was in the US. And that is where the surrogate refused to hand over the baby after birth. And obviously most IPs' worst nightmare. Thankfully, that is actually very rare. That happens, because obviously the surrogate does not actually want any responsibility for the baby in all cases. So just moving on to how this came across in the UK, we had the case of Kim Cotton, who was an English surrogate giving birth to a baby for US parents, and she was paid for it. This caused a bit of a stir in that we didn't have any legislation governing this, and there was a rush to put in that legislation. There was also the appointment of the Warnock Committee to look into this, because what they were worried about was child commodification and exploitation of surrogates. Ultimately, this led to commercial surrogacy being outlawed, and we'll see on the next slide that the legislation was really focused on doing that. Next slide, please. So we had, the only legislation that we had around that time was the Surrogacy Arrangements Act 1985. And what that really did was to try and prohibit all, advertising of surrogacy. So that was both the surrogate advertising their services and IPs looking for a surrogate. It was also illegal to broker that arrangement, and for lawyers, crucially, to draft the surrogacy agreement. Unfortunately, the legislation lacked coherence because it was brought in a rush. But it wasn't until 1990 that we got any codification of that law, and that came in with the Human Fertilization and Embryology Act in 1990, which set out the process for obtaining a parental order. This was then overhauled in 2008 and was aligned with equality legislation to make sure that same-sex couples could apply for a parental order. Now, the case law has stretched the meaning of this legislation because it is long due a reform. And as we'll see on the next slide, lots of cases have come in to look at each aspect of eligibility. What I think everybody needs to recognize is that you do have to understand that the court cannot make a parental order if you don't meet the criteria, even though the case law has stretched the meaning in this. So we'll have a look at that on the next slide. So I've set out here the criteria for obtaining a parental order. Criteria is that there must be a genetic link to at least one of the IPs. And that's quite straightforward. The second criteria is that the IP should be married or in an enduring relationship. That has actually, the law has actually changed on that, and now single parents can actually apply. But again, there has been cases around this idea of enduring relationship because there has been IPs that have separated during the process, and it's been important to recognise that they are still in an enduring relationship for the purposes of the parental order, in terms of the fact that they are going to parent this child together. So the next criteria is that the IPs have got to apply within 6 months of the birth. Again, there was the case of Re-X, which stretched the meaning of this because the application was made 2 years later. The court still made the parental order in that case because it was in the best interests of the child to do so. The next criteria is that the child's home must be with one of the IPs at the time of the application. I mean, this is quite ordinary because after the birth, the IPs will take the child home, so you would expect that. But one of the another stumbling block is that one of the IPs have got to be domiciled in the UK. Now, this can cause problems when you've got foreign nationals living in the UK, and we need to examine where their domicile is. Have they opted for UK domicile, or do they retain the domicile of their home country? You also have to consider whether the person has possibly lost their domicile, their UK domicile, if they've been living abroad. So that really needs careful examination. The next criteria is quite simple. You've got to be over 18. But the next criteria is a little bit more misunderstood, in that the surrogate and their spouse have to give unconditional consent to the parental order. And that is because upon birth, the surrogate will be deemed the legal mother. And if they are married, their spouse will be deemed the second parent. If the surrogate is obviously not married, then the biological father can be cited as the second legal parent. The next criteria is that the surrogate must give consent, but there has to be 6 weeks after the birth, and that is a mandatory cooling off period. And you can imagine that the reason for that is that if you've just given birth, it may not be possible to give valid consent. Finally, the expenses incurred by the surrogate must not be commercial in nature. So that is something that I'm going to be speaking about in a little bit more detail later on in the slides. So next slide, please. So how do you get there? How do you get to the point of having a baby by surrogacy? So the IPs will have to join an organisation such as Surrogacy UK, COTS, or Brilliant Beginnings. They're the sort of big three. They will then do DBS checks, medical reports, and interviews with representatives of those organisations to make sure that they're appropriate for surrogacy arrangement. Then they will need to pair with a surrogate, very crucially, usually at a mixer event.
And so, Fiona, what's involved as part of that mixer events and the pairing process?
Yeah, it's a good question. So they will usually be something like a picnic or something of that nature, where IPs can mix with the surrogates. I mean, they're really looking to make a connection with the surrogate because they are going to go through this journey together. And if they can be friends, and obviously that is going to be quite key. The crucial thing to recognise about this situation is that the IPs cannot ask the surrogate to be their surrogate. It's really the surrogate that has to identify which IPs they want to pair with. They will notify the organisation, and then there will be a period of getting to know each other, usually around 3 months, where they will have one-on-one time to make sure that that is an arrangement that's going to work out in the long term. So once they're sure that they want to go ahead, you're then going to sign the surrogacy agreement. Now, that is very comprehensive in terms of what it covers. You'll obviously be covering things like consent, but other things that might not have occurred to you, such as problems during pregnancy. What if there is a genetic disorder or something of that nature? Would you agree to terminate the pregnancy? Would the surrogate agree because it's her body? These things have to be discussed. The expenses need to be outlined and finalised. You need to know what you're going to be paying the surrogate and what it's for. Who's going to go to the scans? Who's going to be pregnant at the birth? Very crucial. Who's going to be holding the baby when the baby is born? Is it going to be handed to the IP straight away? All these things need to be looked at in advance. So then we come to conception. Again, that's going to be very straightforward. If it's IVF, it's going to be in a clinic. If that is at the, if this is going to be the surrogate's egg, it's going to usually be at their home by artificial insemination. So again, at the birth, once the baby is born, crucial to recognise the surrogate is the legal mother. This can be really important. If there was some sort of medical issue with the child at birth, you're going to need consent, possibly to an operation. The surrogate is going to have that PR to make that decision. If she's married again, that means that her husband also would have the ability to consent to an operation, which seems very strange considering that they will not be, in practical terms, be the parent of the child. So you can see why parental orders are very important. That is obviously the next step, but of course that's not going to come into effect for 6 months. So you are going to have this legal limbo where you have the surrogate potentially having the ability to make decisions for your child when you don't. So this is why the area is ripe for reform. The way around that could be a child arrangements order that will give you parental responsibility, but usually, again, because that's going to take time to come in, people are just going to go for the parental order because that is going to be a complete remedy to the situation. It's going to give you PR and parenthood, and you need both of those things. It may seem strange that that is not mandatory to get the parental order, but that is the situation at the moment. So it is suspected that there are a lot more people with surrogacy arrangements that do not have parental orders that show on the statistics. Again, once we get legislation and more certainty, I think that should change. So the final step will be, if it's a domestic surrogacy, you're going to re-register the birth certificate to put the IPs on the birth certificate. If it's a foreign surrogacy, you are going to be getting the UK birth certificate for the first time. Next slide, please. So some international considerations if you are thinking about going abroad. You still need to get the parental order in this country, even if you have satisfied everything you need to do abroad. Again, it's really important to think about domicile and habitual residence of the IPs and the surrogate. And Sarah's going to talk about that in a lot more detail about why that's important to consider. What I would say is that you need to be wary of relying on the expertise of the Foreign Surrogacy Agency as to UK law, and you need to cross-check that back to UK advice. Don't just rely on the fact that they will understand what is going on here. They may want, especially if the commercial surrogacy is allowed in that country, you don't effectively want to be sold something to find that it's not going to work when you get back to this country. Again, in terms of obtaining valid consent, please bear in mind that you might not have any contact with the surrogate after the birth. So you really need to make sure she's able to give consent 6 weeks after the birth. Where is she going to be? Do you know where she lives? These are the sorts of things that you really need to consider. Again, might it be worth your while getting independent legal advice for the surrogate so you can show that they have freely entered into the situation, there's been no exploitation there? Do you need translation of documents? Do you have direct communication with the surrogate? Do you have their phone number? These are things that may seem obvious, but when you have an agency acting for you, they will quite often be the point of contact rather than the surrogate themselves. You also need to check whether the surrogate is married, which again is going to come into immigration that Sarah's going to cover. That's very, very important. And preferably you would want the surrogate to be single in some cases. You don't want that second legal parent to be her husband if you can avoid it. Again, this doesn't happen everywhere, but if you are going to be deemed the step parent because there's no biological link to the child, you need to check whether you need to adopt that child locally. That actually occurs in Iowa in the US. Next slide, please. So home or away, what are you going to do? I think most of the reason why people travel abroad is because there is more certainty abroad than there is in the UK at the moment, but you must bear in mind that there is no international consensus, there are no treaties that we can follow. So this can lead to conflicts of law, and that needs to be considered. You really need to check in the country that you're going to, what are the safeguards they have in place, what is the eligibility criteria, and what is the legal process. You need to know what the legal process is, but you also need to know, do I qualify? Some countries will not permit homosexual relationships, and they will not allow that in terms of their surrogacy laws. You might have to show that you've got a medical condition to be permitted to do it as well. So you need to know what personally you meet up with that criteria. Something that could be an advantage abroad is that you might not need to have a genetic relationship. You might be able to use both donor sperm and donor eggs to create the embryo. We can't do that in this country because there needs to be a biological link with one of the IP. So that could be an advantage. You need to think about who's going to be named on the birth certificate. Again, Sarah's going to talk about that in more detail. You really need to get immigration advice before you embark on this kind of trip, because as we'll see, this is quite complicated. Other things you might want to be thinking about is ethical considerations. What is the poverty like in that country? Could illiteracy mean this leads to exploitation? This has happened in the past, and there is many, many cases, and I would urge you, if you're interested, to read the case law to see what can potentially be pitfalls in this, with this idea of going abroad. Also, we're coming to the end of this, hopefully in this country, but you do need to think about COVID in other countries, because they may not have the vaccination policies that we have in place. That could cause an issue. So next slide, please. So I'm not going to run through all of the rules in every single country because they're set out here on the slides, but I just want to pick up a few points. Lots of people might be surprised to learn that most of Europe, it is illegal to have a surrogacy arrangement. So for example, in France and Spain, that is illegal. In fact, in France, there was a case which is listed there, Menacin in France, where it wasn't possible to register the birth of the child once the surrogacy arrangement had happened abroad. This means that you couldn't get the birth certificate and passport in essential documents. And actually, this was deemed to be a breach of Article 8 rights. So that has been changed, but you still need to adopt your child, even if there's a biological link in France. So in terms of other countries where you might hear about surrogacy, Greece, that's been enforced since 2002, but very, very strict criteria there. They will only allow heterosexual couples, and you need to show a medical reason. But the good thing is that you will be recognized as a parent from birth. Portugal, very progressive. They approve surrogacy arrangements by committee, and you will be named as the parent from birth. Next slide, please. In terms of the rest of the world, you've got to remember that some countries have a regulatory approach, some countries have a medical approach. So when I say a medical approach in Japan, it means that you need a doctor to oversee it, and then you will adopt the child. In other places such as Israel, there is a regulatory approach, and that's been enforced since 1996. But again, really, really strict criteria, and you need to still apply for parenthood post-birth. And please do bear in mind, you're going to have to do that process again when you come back to England. So that might not be an option for a lot of people. Again, lots of surrogacy arrangements used to happen in India, but that commercial surrogacy has now been banned since 2016, and that is due to widespread exploitation. South Africa and New Zealand, both quite progressive countries in that respect. You'll see there that New Zealand, again, approves by committee, but you still have to adopt. So a real range there across the world on approach to surrogacy. Can I have the next slide, please? So-called surrogacy-friendly destinations are the US and Canada. The US see themselves as a very safe area for surrogacy. But please remember that it does vary from state to state. There is no federal law. This will be completely on which state you go to. California, a very popular destination. New Jersey is another popular destination for this. Again, you will be getting independent legal advice from a lawyer on that. That's different to England, and you will be entering into an enforceable contract in the US. Lots of protection for both sides, and that's why some people think that that's a much more preferable situation. You're going to be named as the parent from birth, and your baby will also be deemed as a citizen. This is really important for obtaining a passport, and another huge advantage of going to either the US or Canada. Canada, very similar to the US in that respect. Next slide, please. So just to touch on it again, with the US, there is a lot of reproductive tourism there, and they have additional things such as psychological screening, independent legal advice, all these safeguards that mean that the process should run a lot more smoothly. The big disadvantage, I suppose, of doing it in the US is, and stops people going there, is the cost, which often reaches about 140,000 US dollars, with about 30 to 40,000 going to the surrogate. So you can see it's very expensive. Lots of pros and cons to everything that you need to look at when you're looking at your country to go to do your surrogacy arrangement. So next slide, please. And this is going to be relevant. So the Ukraine is going to cost a lot less Same with Georgia, but again, you're going to have to be a bit more careful about the fact that it can take a long time to get a local passport because the child is not going to be deemed a citizen of the Ukraine. That can take 16 weeks. Now, that's a long time to be waiting in a country to bring your child home. So you really need to have a look at that if you are considering that sort of country. And it may be that you have to because of money. So lots of things to weigh up here. Next slide, please. So as I touched on just before, bringing the baby home is going to be complex. And you need to have a look at that. So the child's citizenship, nationality and immigration status is going to depend on the surrogate's immigration and marital status. So you really need to have that nailed down and understand what that situation is. The position can be even more complicated if the IPs have got multiple national identities. You know, you can imagine somebody like, let's say, Elton John, who went through the surrogacy process. You know, where does he consider himself to be based? So we need to be thinking about, do we need a British passport? Do we need a local passport? Because the crucial thing to always bear in mind is that the law applies extraterritorially. So you may have satisfied everything that you need to do in the foreign jurisdiction, but you will be back to square one when you come back to the UK. The UK courts are going to see the surrogate and potentially her husband as the parents and having PR. So you really need to think about that. There is a risk that your child could be stateless and technically parentless, especially if you go to a country like the Ukraine, sorry. That is going to be important if there is going to be any medical issues with the child and issues of consent and who can give consent, as you can imagine. So really what we're saying is you need to speak to an immigration lawyer as well as a family lawyer before you embark on something like this. And you really need to particularly be looking at the expenses, and so that you're not to be seen as entering into something that might equate to baby buying in the eyes of the UK court. Technically, there has not been a case yet where that has been, the parental order is being turned down yet, or that, to my knowledge. They're usually accepted on face value, but you'll see that there's a huge difference between the costs in the Ukraine and the US, probably to do with the economies in those countries, but you really need to consider that carefully. So I'm going to hand over now to Sarah, and she's going to touch on all of the immigration issues that I've just been raising in a lot more detail. Thank you, Sarah.
Thank you, Fiona. And yes, absolutely. Preparation and advice early on is the message. If you can prepare for every sort of eventuality, all of the considerations, you'll have a much smoother route panned out and a better ability to deal with problems that you may then encounter that weren't predicted, rather than really trying to grapple with everything as you go along. So in terms of introduction to the sort of nationality and immigration section of this talk, I've just set out here a bit of background at the start of the slide that you can delve into if of interest in more detail yourselves. But effectively, what I want to stress is when you come to arranging for your child to come back to the UK, if it is an overseas surrogacy, you need to consider the immigration implications of that and the nationality implications of that. And it is not automatic that even if you yourself as an intended parent are British, or both of you are British, it is not automatic that your child would be so at birth when born overseas in particular. So this aspect of the talk is really concentrating on overseas children born overseas, and with the rationale that, as Fiona has set out, a lot of the surrogacy arrangements are taking place overseas at the moment still. So you're not British automatically as a child born overseas, and that is because in the second half of this slide I've set out, that is because of the definition of who is the mother and who is the father or the other parent. And the similarities here as to what Fiona has already outlined with the different definitions in the country where the surrogacy takes place. So as you heard in the USA, the intended parent will be classed as the parent at birth, but not necessarily in the UK, and it will vary from country to country. In nationality law, you have another layer of definitions as well. So in nationality law, as far as the UK is concerned, a mother is the person who is giving birth to the child, so that will be the surrogacy mother. Okay, and that's regardless of whether the egg for conception comes from the intended parent mother. The father or the other parent will depend again on the surrogacy mother's marital status. So that's not necessarily something again that you would think from a starting point, but that is the case. Surrogacy mother, if they're married, the husband or the spouse of the surrogacy mother will be classed as the other parent of the child at birth, as far as UK nationality law is concerned. However, if they're single, so if the surrogate mother is single, then there is a possibility of the intended parent father, for example, to be classed as the other parent, as the father of the child from birth. And that, again, for nationality purposes, will depend on satisfying the Secretary of State for the Home Department of the father being the natural father being the definition in the nationality law provision. So the onus is on the parent. So it's the parent that needs to satisfy the Secretary of State of that, and will most easily be demonstrated by a DNA test, for example. And Fiona already touched on the circumstances where you would need a DNA test as part of the surrogacy process in any event. But you could also have the birth certificate, for example. Fiona mentioned that in some countries, the intended parents are listed on the birth certificate straight away. Or you may have a court order from, for example, that other country, or a court order here in the UK. So those pieces of evidence would go to establish a father, the intended father being classed as the father for nationality purposes. So for those reasons, for those definitions, and those really the differences in concepts across these different areas of laws, it's important to identify the child's status effectively, tracing the child's parentage, and then how we can bring in the nationality from there.
Seems to be lots of definitions.
Yeah, a lot of definitions. So again, another reason really why it's important to seek that advice from an early stage, and to have that specialist input. So specialist input on the family, and then specialist input on the nationality end. And the nationality definitions haven't changed for a long time. They've been adapted bit by bit in terms of the progression in with surrogacy and adoption and same-sex marriages and so forth, but there's still a long way to go. So you may have two scenarios that you see at the bottom of the slide. A child may be subject to immigration control. So for example, if they're American by birth automatically, which follows if you're born in the States, then unless you can prove the British nationality link, that child would be subject to immigration control. So if that's the case, we would go down the visa route, but otherwise there may be a route to become British automatically, or to be classed, as British automatically, or to become British by registration. So on this slide, again, reiterating that it's important to determine who the parents are at birth, because there will be different sets depending on the country, and as we've seen, depending on the various definitions. You can then rule persons out. You can then concentrate on who you're looking at in terms of a parent to determine any nationality rights or any immigration rights for the child. And you would first really look to establishing whether your child, through the surrogacy, is British born. And because that would be the most straightforward, you can then apply for a British passport straight away. So I've tried to just outline that in a nutshell. It's quite complicated in terms of the nationality law provisions, but effectively you're looking at the parent's nationality status firstly, and whether either parent, so it doesn't need to be both, but whether one of the parents, and how they are British. So whether they are British in particular, otherwise than by descent. And so descent here is the term in terms of descending from a parent, so in terms of ancestry, rather than a dissenting judgment, a disagreeing with something. And basically a parent who is born in the UK, so if I'm born in the UK, I would be British otherwise than by descent, because it's the very fact that I'm born in the UK from a British parent, for example. But if I was born overseas to a British parent, then I would be British by descent. I'm only British because of my parents' British citizenship. And that's where it gets tricky, because I would then not be able to pass my British citizenship down to the second generation. So there's a sort of stopgap to how often a British person can pass down their British citizenship. So in most cases, if the parent's born overseas but is British and the child is also born overseas, then that child would not be able to benefit from their citizenship from their parent. So when would a child be British born? If they are born as part of a surrogacy, and if that surrogacy is overseas, so the child is born overseas. You really have two scenarios that may be the most common that you come across. The first, less common though, and that is that the child is born to a surrogate mother who herself is British, otherwise and by descent. So that may be less common in terms of the likelihood of that happening, but perhaps the surrogacy has taken place through someone that is known to you as an intended parent, or you know, there's some acquaintances.
Could that be family or something?
Yeah,
like that?
exactly. It could be a family arrangement that obviously passes through all of the requirements nonetheless, but you know, there's some sort of link to that locality, or there's a link to that community that meant, you know, the sort of a link there. But aside from that, the other more perhaps common scenario is where the child is born to the surrogate mother who's completely unrelated to the intended parents, but that importantly, that surrogate mother is unmarried. So the spouse of the surrogate mother, you know, it doesn't come into the picture here because there isn't one. And then the focus can be on the commissioning father, so the intended parent father, who again, importantly, has a genetic link to the child. And the last factor that we need to tick all of those boxes is that the intended parent father needs to also be British, otherwise and by descent. So that father would then be able to show their biological link, will be able to show that they're the natural father, coming back to that definition in nationality law, and so would be able to pass down their citizenship to the child automatically at birth. So in that sense, you've got a fairly straightforward scenario, and you could be applying for the British passport where you are, so in the country where the child was born, in order to come back fairly speedily. So if I can have the next slide, please. So just as a run through, again, the reasons why it's important to trace the parents, to trace that lineage in nationality law terms. And that is because you're not automatically British as a child when you're born overseas. And why I thought it useful to put that summary slide is because you can then trace the reasons why that may be so. And then that will help you map out what you need to do, or at least give you the options to consider and to choose in terms of how you can resolve, how you can document your child's nationality. And so just running through here, a child would not be automatically British if the surrogate mother is married, for example, and is obviously not British. So neither her or their spouse are British. The commissioning father, the intended parent father, is British by descent, so they can't then pass it down. The commissioning father does not have a genetic link to the child, and so they can't then benefit from that natural father definition in nationality law. You'll recall Fiona mentioning that as far as England and Wales is concerned, in terms of surrogacy, you need at least one biological link with the intended parent, but obviously that link could come from the intended parent mother. So you may have a situation where there's no link on the father, on the male end. And then lastly, there is no commissioning father at all. So that could be in a same-sex female relationship that are the intended parents, and where, for example, sperm donor is used. So that's the summary. And so we'll look at now in terms of the next slide, what you may need to do, what you need to consider when you're looking at establishing your child's British nationality. And so the first option is to do so through the parental order. So you will have you've been taken through by Fiona in terms of that procedure in the family courts in England and Wales. But it also can benefit you as intended parents and the child on the nationality front as well. So that's in section 1.5 of the British Nationality Act of 1981. And that section provides that a child who is the subject of a parental order made in a UK court, so made in England and Wales, becomes British from the date of that order. So in other words, upon the making of that parental order, the child is British. So from that date onwards, the child can be considered as British. The requirement, in addition to what I set out there, importantly, is that that is as long as one of the intended parents is British as well. So it does need to, again, be traced back in terms of parentage. But that will, again, lead to a fairly straightforward situation where you can apply for the British passport straight away, but only following the making of that parental order.
Is that the same for adoptions?
That's right, Fiona, absolutely. Yeah, so it's the same section that actually first dealt with adoptions. So upon the making of an adoption order, as long as one of the parents, one of the adopting parents is British, then effectively it's trying to replicate that procedure as if you were issuing a birth certificate effectively with that child being born in the UK. So it's a similarity, and bringing surrogacy in along in line with that, with the provisions that were already in place for adoptions. Having said that, this first option is good because it doesn't add a layer of bureaucracy, a layer of court procedures to your situation, because obviously you will have to do, you don't have to, as we heard from Fiona, it's not mandatory, but it's advisable that you do the parental order as part of the surrogacy arrangements, and to establish that those legal rights in respect of your child. And it's the same procedure that can benefit the child in terms of nationality in those circumstances. But having said that, there may be reasons why you don't want to leave it to that. So your family proceedings, while we all wish for those to be fairly smooth and fairly swift, often aren't for whatever reason. There may be an issue of consent, there may be an issue of just delays in the court system, whatever that might be. So you may not want to wait for the parental order to be finalized and made in order to document your child in terms of a travel document, or document your child in terms of their nationality rights. So in those instances, you can turn to other solutions. And similarly, these solutions can be also done in parallel if that's what you would prefer to do. The second route is the registration as a British citizen, which is an application for registration to the Secretary of State for the Home Department, in other words, the Home Office, if you're making that application here in the UK. Or you can make that application abroad as well at a consular office or British High Commission / British Embassy, depending on where you are and whether the country is a Commonwealth country or not. So those applications are made under section 3.1 of the British Nationality Act. So the same piece of legislation, but different section. And importantly, as you can see from the first sub-bullet point under paragraph 2, is that this is a discretionary application, okay? It's important to realize this because there are several ways of registering children as British nationals, and some are by way of entitlement. So if you meet all of the criteria, you have a right, you have an entitlement to be British as that child. But this is not an entitlement, it's a discretion. So it is effectively if the Secretary of State sees fit to register the child. So there may be reasons, or if you haven't evidenced your application sufficiently, there is room for the Secretary of State for the Home Office or the Embassy to refuse that application. So it's important to seek advice, to understand the different provisions that may apply to your particular situation, and to then prepare accordingly. The guidance, the Home Office guidance, which I've set out there, is very detailed and does cover all of the relevant scenarios or the most common scenarios. But it also, interestingly, differs in terms of the criteria. The guidance differs depending on which parent you are tracing back to. So this process of registration and the discretion to be exercised when it's a surrogacy case does depend on the parent whether they're British themselves, and then secondly, which parent we're dealing with here. So the first scenario that I set out at the end of this slide is the commissioning father, intended parent father, and when they have a biological link to the child. You have the words here, Secretary of State must normally register, so that's taken from the guidance, again implying that discretion. So normally does provide the power to depart from that, to effectively refuse, but the word must is really entailing a sort of a high likelihood of the application being successful. It's not a duty, because again it's a discretion, but it should be okay, it should be successful if all the boxes are ticked and the Secretary of State is satisfied of that. And those, the boxes that need to be ticked are set out at the end. You need to be satisfied that, or they need to be satisfied of paternity. So we've covered that already in terms of DNA test and so forth. You need to have consent of all those with parental responsibility. So that, in terms of how much or how many consents you need to obtain, may very well depend on where you are at in the sort of surrogacy procedure and the family law end of things. You may still have the surrogate mother with parental responsibility, depending on when you're making that application. You may still have the surrogate mother's spouses as someone who has parental responsibility. So there may be several there that are relevant, or you may have it pared down by then. It very much depends on where you are at in this stage, but you will need that as in support of this application. A good character, less perhaps relevant, especially if you're doing this application early on in your child's life. It is only for children over 10, which is the age of criminal responsibility. It happens quite rarely, again, that criminality or good character is an issue here, but it is there. So just be mindful of that. And lastly, you're looking at the father, had he been married to the surrogate mother. So we're coming back to the mother being the definition of surrogate mother, the woman who is giving birth to the child. If they were married to the surrogate mother, the child would have been born automatically British, or entitled to be registered as such. So you're looking at the hypothetical situation, and that's where the Secretary of State here and these provisions in the nationality law have tried to progress things, have tried to bring surrogacy arrangements when they are undertaken in accordance with the legislation in England and Wales, trying to bring them as close as if it was your own child. So in the next slide, we're just going to look, I'm going to run through a bit more quickly in terms of the other scenarios, because some of the guidance is replicated. And that is when the commissioning father doesn't have a biological link. So your biological link, if you're undertaking a surrogacy, which is to be recognised by the UK, the biological link would need to come from the intending parent mother. So in those situations, again, must normally, so the same level of discretion and sort of expectation. The criteria is slightly more onerous. So you have to have consent, which is the same in terms of all those with parental responsibility, but that includes a notarized statement of consent from the surrogate mother. Okay, so you've just got an added layer there that you need to arrange for. Same provision in terms of likening it to the child being their own child born without being a surrogacy, that had he been married to the mother, the child would have been born automatically British or entitled to registration. So just trying to bring that in line with the provisions relating to those who are married to mothers. Good character requirements we've covered. And then lastly, the father needs to have been granted either an order under section 30 of the HFEA, which we looked at the act earlier on in Fiona's talk, or an order by a foreign court within the jurisdiction that the child was born, an order by the foreign court within the jurisdiction that the child was born, directing that the father is to be treated as the child's father. Okay, so it's slightly more onerous in terms of procedure there. And then on the next slide, we're looking finally at the scenario on the mother's end, so the commissioning mother, the intended parent mother, when it's her citizenship that is relevant here. We've effectively got the same set of criteria as with the father with no biological link. And you need consent of all of those with PR, but including that notarized statement from the surrogate mother. And then the same, had it been the commissioning mother who was giving birth, so who was meeting the definition of mother under the nationality law provision, then the child would have been born automatically British or entitled to be registered, and in the same good character, or one of those orders being granted, including the foreign courts order. So fairly similar in terms of criteria. So if we can look at the next slide. We're moving away now from the nationality law provisions, and the third solution, the sort of third route that persons can explore in order to enable the child to travel to the UK is applying for a visa.
And is that more simple, Sarah?
Yeah, I mean, yes and no. So it may be more simple for the complex nationality cases, because if you have an issue of evidencing that, if you've got an issue with documentation, or for example, the registration applications to the Home Office can take time. So in that sense, you may want to sort of short circuit things and apply for a visa in parallel. Another example why you may want to do that from the point from the start is, for example, you talked about the USA, and a child born there would be automatically a US citizen. They can then automatically apply or fairly straightforwardly apply for an American passport. So they've got a travel document fairly early on in the process. So instead of tracing back nationality, instead of going through that road, down that road as far as the UK is concerned and taking that time, you could just apply for a visa to come back to the UK and then obviously resolve any issue of citizenship later. So in that sense, it has some advantages, but it very much depends on the case, the reasons why you might go down one route or the other, and of course the parents' priorities. So looking at applying for a visa, the provisions now move away from nationality law and into immigration law. So you do have different considerations in terms of framework, legal framework, and different Home Office guidance. So again, important to get the advice if you're not a specialist in this area, and if you want to look at this very carefully. The guidance is very detailed, it's useful to go back to, and it will confirm the various scenarios. And if your child meets the definition of child in the immigration rules, which I won't go into for today's purposes, if you as a parent and as an intended parent meet the definition of the parent in the immigration rules, then you would have an application for a visa as a child under paragraph 297. So for example, the definition of a parent would similarly be the natural father. So if you can show paternity as a father, DNA test, birth certificate, that sort of thing, then you would have an application for that child to come and join you in the UK or to accompany you on your return, as long as the father is British or has permanent residence in the UK. So again, if you're sort of within the immigration rules, if you're within those sort of set criteria, then it can be more straightforward. If you're outside of that, then you have an application that can only be considered, again, at the Secretary of State's discretion, outside of the immigration rules. So I've set that out at the bottom there. If either of the commissioning parents, the commissioning couple, have a genetic connection with the child, then the entry outside of the rules of the Secretary of State's discretion may be possible. But again, it depends on the state of play that you're at, the evidence that you provide. And so if it is an application to be considered outside of the rules, then it is much better to have that prepared carefully and well evidenced. An example that could assist you in making an application outside of the rules would be what you touched on, Fiona, earlier, in terms of if the child is considered stateless, if there's an issue with regards to the child's nationality status full stop, for example, if born in Ukraine. So that could be, again, a sort of compelling factor, an exceptional factor that could mean things need to be speeded up, but also the discretion should be exercised in your favour. So if we could have the next slide, please. That comes to our conclusions, or brings us to our conclusions. And really just, I wish to reiterate that the options that are available to intending parents are very dependent on several sets of factors. So it's trying to summarize that, the first is the nationality and the marital status of the surrogate mother. It does really start from there. And as we saw, a surrogate mother who's married will then potentially exclude really the intending parent father, for example, being listed as such in terms of nationality rights and immigration rights. The second set is the biological links between the intended parents and the child, because again, that affects the sort of criteria that the Secretary of State in a registration application or in an immigration application would look at. And lastly, the nationality and the immigration status, as far as the UK is concerned, of the intended parents of the IPs, because again, that will depend on what you can pass down and so forth. So there's really a lot of factors to grapple with in some cases. And as you mentioned, Fiona, if you've got multiple nationalities or complex immigration status, it gets even more complicated. So we hope that you found that useful. And it just stresses again how prepared parents need to be.
Absolutely. Thank you so much, Sarah. That was a really brilliant run through of all the considerations you need to be thinking about. So what we would say is that if you are thinking about embarking on an international surrogacy arrangement and you do have any questions, I know Sarah would be very happy to hear from you, and as would I, and our email addresses are there for you. We're both on social media as well, Twitter, Instagram. Please do come and approach us and we'll be very happy to hear from you. Thanks for listening.
Thank you, Fiona.